Evening. Thanks for coming out on a Wednesday in September. Before we do anything else, could we say a big Oregon welcome to Dahlia Lithwick? My name's Adam Davis. I'm with Oregon Humanities. This is the kickoff to a series of Consider This conversations on a theme, the people and the public. And so we're really excited to start by talking with Dahlia about things like the law, the courts, justice, other big questions, public trust, stuff like that. And we're going to jump in just a minute. I want to do two things before we start. I want to say a couple thanks, and then I want to ask you a couple questions that will help Dahlia get a sense of the room. So mostly I want to thank the National Endowment for the Humanities, the Oregon Cultural Trust, the Susan Hammer Fund of the Oregon Community Foundation, and the Standard. Thank you for supporting this series and other events around the state. So thank you. So questions for you, and really also for you. First, if this is your first Oregon Humanities Consider This event, could you make a little noise? Welcome, thanks for coming. If you've been to one of these before, could you make a little noise? Okay. It's close, it seemed even. All right, if your work in the world, and it doesn't need to be your paid work, but if your work in the world has something to do with justice, could you make a little noise? Last question, a little bit more complicated. It takes a little bit to explain. I'm going to ask you to make noise in proportion to your confidence that law is a good way to make the country more just. So could you make noise in proportion to your degree of confidence that law is the way? Okay. So a couple of very excited lawyers in the room. Dahlia, now you know who's here.
I do.
And there's lots to talk about related to the book Lady Justice, related to what you talk about on MSNBC and Amicus, and what you write about in many places. But I want to start not out there. I want to actually start with a question about you and when you were a kid. If you can remember a time, one time, when you felt a strong sense of injustice, when you felt like something was wrong and what that thing was and why you knew it was wrong.
So first of all, I want to just say hello, Portland. I want to thank Adam and his team. I want to thank the good folks at Lyceum, which are my lecture agents who, believe it or not, have been representing me without knowing me for some time, and it's just a treat to have them here. I'm going to give you just the worst answer to that question, because it's usually you get a softball, but this is kind of like it's like a hard ball, and it's like pushing me off the plate. My mother says that she knew I was going to be a lawyer when I was about 10 years old, and she gave me a clothing budget. And she said, this is the amount of money you can spend on your clothes this year, and you can decide how to do it, but this is how it's going to go. And I was enraged. I was just like, I have two brothers. They can wear crappy clothes. I have to wear good clothes. I'm a girl. Clothes are important. Everybody is going to, I created this manifesto, pages of furious, urging her to rethink. I thought I just deserved all the clothes all the time. And no, but it's awful. It was awful because I was a monster. And to this day, my mother is like, you were scary. You were a scary, scary little girl.
So, I just want to say, it's interesting that thinking of an instance of injustice and you're thinking about anger, rage, and being scary. That's interesting for starters.
Yeah.
And it makes me want to ask the other side of that. Can you think of a time as a kid when you thought, this is justice. I know what this feels like.
Wow, these are really hard. Are they going to get harder?
It's just going up.
Because I am going to order a drink.
Well, there are plenty of people who would bring you a drink if you want one. So for real. But no, they won't. They'll get a little harder. But justice.
Let me think. Justice as a child. I think this is just going to be incredibly unfair, but my big brother was kind of a thug, and he just was extremely. He just was called me names. I'm just going to tell you. He used to call me Dahlia for a really long time. Right? Mean. See, these are just the things that drive you to law school. And I think probably when the very rare times when I think my parents were yeah, that really, really is not just normal sibling behavior. That is beyond sibling behavior and would discipline him. I think I would feel there's people in the sky who are imposing justice in a way that makes the world make sense. And I think, when I think about, I know this isn't your question, but I think about the way we have gone wrong in this country, my answers kind of dovetail with both of those things. I think just with respect to the clothing allowance story, the ethos of scarcity in this country, that other people have stuff and I don't, which infects every single part of, I think, how the Supreme Court thinks about justice right now, right? Your kid goes to Harvard, my kid can't go to Harvard, then we must have a problem, right? If those people can't adopt Native American children from tribes and the Native American tribes get them, that's not fair to those people, right? It's this constant grinding ethos of anytime anyone gets anything in America and you lose, that's injustice. It's a very childlike view of it. And then just the flip of that, when you feel you get justice, which is what? When Sky Daddy tells you you're right. That's both of those things are totally childlike views of justice that I feel have completely infused the way we think about law and justice in this country.
Great. That actually feels right on, and it feels like a helpful way to start thinking about, what you said about the sort of people in the sky that are going to do the right thing where justice is concerned. And maybe one more. This is not a childhood question. It's as we move towards the question of law and the courts. And I guess I wonder if you could talk about how it is that you decided or came to sort of start paying attention to the Supreme Court specifically. Why was that the thing that you were this is where I'm going to put my attention?
So this is a funny story because I went to law school. I probably couldn't have named, other than Sandra Day O'Connor, who was at the time, when I applied to law school, the only woman on the Supreme Court. I don't think I could have named 4 justices. I just didn't think about the court very much. I went to law school because after college, between college and law school, I worked at Paul Newman, had a camp. At the time, it was only one camp. Now it's a whole network of camps for kids with terminal illnesses and cancers and blood diseases. And I worked at the camp for a couple of years between college and law school and wrote a book about it. And what I realized was that every single kid that I worked with at the camp would have been better served if they had a lawyer than a doctor. They were navigating health insurance. They were, all of them, navigating a just complete Byzantine system that made it impossible for their families to, both give them health access and eat and take care of them and have jobs. And I realized really quickly every single one of those kids needed a lawyer. And which, ironically, Becca Heller, one of the chapters in my book, describes, right, when she starts working with migrants, how every single one of those people needed a lawyer. So it was not oh, I want to be an attorney and, do constitutional law, and I'm so obsessed with Anthony Kennedy. Like, that is not what drove me. I would have been the one person obsessed with Anthony Kennedy. But that was not what drove me to law school. What drove me to law school, and this is your injustice point, was the sense that how is it possible that we live in a country where people who hit absolute rock bottom in the luck Olympics, and then what they need is a lawyer to fight for them, and none of them have access to a lawyer. So I didn't even start to really think about the US Supreme Court quite literally until I had worked at Slate for a few weeks. This is a ridiculous story, but I worked at Slate as a freelancer. I covered the Microsoft trial, and then they called me and said, do you want to keep covering the court because you're funny? And I was like, okay. And then I staggered into the Supreme Court building, and I was like, every one of these men looks exactly the same. I mean, they all, Souter looks like Breyer looks like Kennedy, oh, Clarence Thomas, okay, Scalia. But it was so crazy. I knew nothing about it. And then I'll stop rambling. But the funniest part about the Supreme Court press corps, which nobody tells you, is that they march you in order of importance in the world. There is no other press corps in the world where you come to cover the argument, and they're the seats are the rows are A, B, C, D, E, F, G, 1 to 12, 1 to 12, 1 to 12, and they're you are C8. I think C8 was where I peaked. I never got higher than C8. Linda Greenhouse is A1. Dina Totenberg is A1. Linda Greenhouse is A2. And then they make you line up in the hall and march in that order, so that all the B's are ha ha C's, suck it C's, and the D's are mad at the. It was insane, and you walk in like the Medici wedding, right, where you're I am the 17th most important person in the room, and the reason I tell this story is because only the A's and the B's can see. Everybody else is sitting behind these columns and curtains, and so this is the press corps, right? These are the people who are tasked with explaining the court to the public, and they can't see. So the way you know who's speaking at oral argument, right? Obviously there's no television, is that somebody from the press office at the court is flashing hand signals. They're Scalia, 4, and the 4 corresponds to their rank, right? So then you're trying to figure out, and you're looking at your notes, and you're okay, who's that? Well, it's not Clarence Thomas, he doesn't talk. Okay, it's, but you're trying to figure out who's talking, and I couldn't do voice recognition because I had no idea who these people were.
So
I don't know what that story was even about.
Well, I think it's about a lot, and it's interesting where you were talking about the kids who needed the help of a lawyer, and then talking about the entrenched hierarchy even among the press corps and the opaque character of the court. And it seems to me these things are related, and I think it's probably where we're going to go. And so I guess I want to ask about that here early on, this question of, it seems like from reading the book, from listening to Amicus, from listening to other things, you've had both very strong positive feelings. You're drawn towards the court as a tool for improving our democracy, and increasingly skeptical about how it could do that. But the thing I want to ask about, based on what you just said about how you got lined up and marched in, is that the court of the 3 branches seems to be the most hierarchical, the least accessible. And so just want to ask about that. What's the relation between our hopes for democracy from the court and the way it functions in this hierarchical, mostly opaque manner?
That is the question, Adam, and I think the answer, there's so many layers. I mean, you could go, beyond hierarchical, and you can go beyond self-mystifying, there's all that, and then there's just anti-democratic, and there's it sort of, it's all the way down. I guess my first cut at the answer is that the court is in this kind of unique position, right? And this is by design. You can, read the Federalist Papers. This was by design, right? It has neither the power of the purse nor the sword. The only power it has is public legitimacy. And the idea was meant to be that the court would earn that public, forbearance and acceptance and tolerance. And that doesn't happen immediately, right? It takes many generations. Justice Breyer talks about this in all of his books, but, it took really a long time for that kind of capital to build, where the American public said, okay, the court, even though it has no army, even though it has no treasury, even though the American people could just vote to turn off all the lights and, take out the toilets, the court is the decider, and that is very improbable, and that was the experiment. And I think that the choice was made, and this is why your structural questions, beyond just the large D democracy questions, are good ones, is that part of the way the court decided to do that was through this process of mystification, right? They built, it took until the 1930s, but they built a building that looks like a temple, right? It doesn't look like other government buildings. It looks like the Oracle at Delphi. That's by design. The black robes, by design. For many, 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 many years, most of the court's history, if you got a transcript of an oral argument, it didn't say, if you look up the transcript for Brown v. Board, it doesn't say which justice is asking the questions. It just says the court. Because the presumption was they're all these 9 perfect brains in a vat, and you don't need to know, which justice was asking the question. It took years until they realized that, maybe people want to know whether it was, Justice Stewart or Justice Brennan asking a question. But I think it's part of, when we who cover the court would say things like, and I don't want to go deep in the weeds with my complaints about how they made it hard to cover the court, including, in June when you don't know which decisions are coming down, you don't know which days are decision days, you can't possibly, you literally sit there waiting for the jack in the box to, kind of leap out and punch you in the neck, and we call that June. But, it's such a crazy system, and no other court in the world is sort of mystified to the degree that the Supreme Court is, and up to and including not having audio for the longest time, right? We had to fight to get same-day audio. The secret reason that Amicus drops on Saturday morning, which is a kind of sort of improbable time for a podcast to drop, was because for years and years and years, all of the audio archives would go straight to the Library of Congress. You couldn't get audio at all. And then at some point, then Chief Justice Rehnquist was saying, we're going to do audio for Bush v. Gore and the gun cases and the abortion cases and affirmative action, right? You'd get 4 or 5 same-day audios a term. And people like me on the press corps wrote stupid articles saying, you can't pick and choose which are the 5 important cases of the term. If you're the named plaintiff in something that isn't the affirmative action case, you sure think your case is important. And more pointedly, and I did write this at the time, why would you signal to the American public that the cases that are most divisive and ideological and polemical, where the justices are most apt to act out, those are the important ones? Don't you want to just do the maritime law cases and have everyone be like, oh, what they do is so boring, but at least they're unanimous? That seems like a good message. And after I wrote that piece, I got word back, from somebody saying, the Chief Justice read your piece and he just wants you to know we could take all the audio away. And, right? Nice press corps you got there. Would be a shame if something happened to it. So when that's a true story. A couple years later, there was immense pressure on then Chief Justice Roberts. So they took all the audio away, and then there was pressure on Chief Justice Roberts to give the American, there's arguments for not having a camera in there. There is no argument for not having same-day audio. And we know that when you can hear it, people were sitting in their cars and listening. And so what did the Chief Justice do? His grand bargain was they would drop all the audio for the week on Friday at 6 o'clock at night, when every journalist except Nina Totenberg is drunk in a bar. And so it was the best possible way to be look at how transparent, we are, and also give us something we couldn't work with. And we just made Amicus a Saturday morning show for no other reason than the subversive plan to get oral argument in people's ears. So I think that, like, it's a huge, long-winded way of saying that I think the error, and we're really seeing it now with the leaks, the error the court has made is the choice to sort of less and less and less transparency, more and more and more blame the messenger, right? Get mad at the press corps, get mad at critics. And there's this sense that, like, a public legitimacy is not something that the public confers on them, but something they have conferred on themselves. And when it's threatened, they come out like hot and crazy. And so I think the answer is we are really now, I think, living in kind of the detritus of a really bad set of plans about we'll hide everything, we won't file financial disclosures, we'll go on super yachts, we'll do all this stuff, and nobody will find out. And then when people find out, the answer now is you're delegitimizing the court.
Mm-hmm. So there's so much in that comment, including what you said a couple minutes ago that it used to be that opinions were just attributed to the court.
Not opinions, questions in oral argument.
Questions, I apologize,
Yep.
Thank you. And now they're attributed to the individuals, and I can see arguments, at least in principle, that it would be better if it were not attributed to individuals. In a way, we're so aware of the individuals on the court that the court seems to have disappeared behind the individuals. So I want to ask you about that. How did that happen, that we're so aware of the individuals that we've sort of lost sight of the court? And is that a good thing, that we've seen the individuals come more into our sight?
I mean, I think you're exactly right. And I think most court watchers attribute this phenomenon to two things. One is the just celebrification of everybody, right? And so, Sonia Sotomayor is throwing out the first pitch at ball games, right? And Justice Ginsburg is a rapper icon, and like this is not the way I came up, right? For those of you who are old enough to remember, after the book The Brethren came out, which was really like a peel it all out, throw it on the ground, and let people see how the sausage is made, that was such a catastrophe for the court that really, after The Brethren came out, the court sort of like locked down on nobody's giving public speeches, nobody's doing appearances, nobody is talking to the press. The law clerks, most of the time that I was covering the court, the law clerks, if they spoke to you, it was at their peril. It was understood if somebody leaked, if a clerk leaked anything, they will never work in Washington again, right, with the $500,000 signing bonus that comes with that. So honest to God, when I first started covering the court, I had a very good friend who was clerking, and when she would meet me for lunch, she would wear like a hat and dark glasses and like almost the fake mustache, like terrified of talking to the press, and that really held. So I think part of what happened is somewhere in the mid-90s, and I remember Justice Scalia naming this, he said, we've all been super quiet, we never talk, we don't do public events, we don't go on TV, and then he used the word, I think it's time for us to come out of the closet, is what he famously said, which I think that those words don't mean what you think they mean. But he really felt like if everybody was talking about the court, he needed to be in the conversation. And then more and more you would see, right, justices writing books, and justices, going suddenly, Justice Breyer is on like, wait, don't tell me, and suddenly, all the justices are on TV. So I think there is this celebrity thing that starts, and now it's off the hook, right? Now it's truly the case that the justices are rock stars. When I first started covering the court, there were like stories every single year about people handing their camera to Justice David Souter and not knowing he was Souter and being like, can you take our picture? Nobody knew who any of the justices were, just the same way I didn't. I think the other thing that happened in addition to this sense, and by the way, this starts to inflect in the doctrine, right, where you see justices writing, and Professor Dean Erwin Chemerinsky has really, I think, salient thoughts on this. They're starting to write sort of sound bites, right? They're starting to write dissents that they know are going to be, turned into a TikTok or turned into a thing, right? So it that sense that what you want to do is sort of do the throwdown line at oral argument starts to ramp up. And then the other piece is just confirmation hearings. I mean, I think we forget, again, that throughout most of history, confirmation hearings happened on paper. It wasn't until, I think Justice Brandeis was the first one who went to his own confirmation hearing, and only because there was rampant anti-Semitism that was going to scupper his confirmation. The first televised confirmation hearing was Sandra Day O'Connor. Until then, this was a 5-minute, yes, no, of course, yes, they're fine. They breathe, they ambulate, they're in. There was not, and then suddenly it turns into this sort of telenovela, 5-day event of screaming and crying and the wife and the, senators and the gotcha. And I think both of those things, to just go to your question, absolutely delegitimize the court because it makes it a kind of cult of personalities. And I think that the justices, with some exceptions, have kind of let that dictate how, not just how they behave, but as I said, sometimes how they write.
It's interesting to think that impulses toward transparency in some way might end up running against the court's ability to do what it most ought to do. It sounds like some of that is happening there. It makes me wonder what we most should hope for from the court. When you said that the justices have become celebrities, in a way they've become celebrities, but they've also very clearly become political pawns, which doesn't feel exactly the same, and so that we almost know what they're going to say before we've read the opinion or the question, because of who says it. And do you have a sense of how or when that shift happened, where you kind of know?
So a couple of things. One thing, and I actually think this is unbelievably important and we've missed it, is that the confirmation process actually changes the justices, right? And so I wrote about this a lot at the time. If you go back and look at the justices whose views on the First Amendment have become most radically anti-press, anti-public access, anti-openness and transparency, almost one-to-one perfect unerring correlation between the justices who had a bad time at their confirmation hearings. And that's not entirely unreasonable, because I think we forget that every single justice who has come to the Supreme Court in modern times comes from an obscure circuit court, right? An obscure somewhere in the Justice Department. These are not people who are used to the Klieg lights of public scrutiny. And so if you look at, Justice Alito, who I really believe to this day is angry about what happened at his confirmation hearings, where you may recall, he was being called a racist for an eating club he was at, involved with in Princeton. His wife, Martha Ann, left the room crying. I mean, that changed the way he thought about the press and the public. Justice Thomas, don't get me started. When you read Justice Thomas, his concurring opinion in the campaign finance case, he's talking about public disclosure as though it's to disclose, your donors is a video game in which, you end up bloody and writhing on the floor. I mean, he really is of the view that public scrutiny of any sort is toxic and dangerous. And case after case after case, there, I think, two of the most extreme iteration of people who just really are mistrustful of the press and the public. And I think that that's not accidentally because they felt that they really, really got raked over the coals, fairly or not, at their hearings. So I think one piece of it is I think we should be thinking much harder. And Justice Kavanaugh, I would say the same. But even, it was very, very clear to me that Justice Jackson was really affected by the sort of what was directed at her in the press and by the Senate at her hearing. So we should be asking ourselves, are these job interviews in which this person is in front of their families, stayed alive for 5 days. Is it worth doing that if they're going to have a lifetime appointment in which they decide what the press does? Like, I just think we have not been very smart about understanding, and I really mean this. It leaches into their views of the doctrine that if your one experience with the public and the press is that they are merciless, feral monsters who want to destroy your life, that might affect how you write about, the public. So that's one piece of it. And then I think that the other piece of it is that we have just entered a time, and we're so in it that we forget that it really wasn't until like the last 5 or 6 years that every single liberal on the court was appointed by a Democrat, every single conservative on the court was appointed by a Republican. Like, that's new. We've never had that. And so we now have a court where, as you said, it's like, you put in a quarter, you get your Snickers bar. I mean, and that's entirely a construction of, you can sort of pick your poison, whether it's, this multi-million-dollar judge-making factory, right, that, raises young judges like hydroponically underground so that by the time they're like in law school, they're already being groomed, right, for the right clerkship and then the right spot on the right, bench. And then, I mean, this is clearly a juggernaut, and we've never had that. And, if you think back to, could Hugo Black get on the court today? Could Justice Marshall get on the court? I mean, nobody could get on the court under these terms. You literally have to be part of a machine. And so, of course, it's entirely predictable because, and this really goes to, I feel like maybe this is the beating heart of your question, which is we've never, in my lifetime, not had a swing justice. And suddenly, I mean, my friends, the swing justice is Brett Kavanaugh. I mean, last term, I think it became Justice Barrett. But, these are not swing justices the way, you could walk into a case, you had no idea what Justice O'Connor would do. You could predict with about 60% accuracy what Justice Kennedy was going to do. I mean, you can predict. And so I think you're right to say there are no surprises. And I think that's because the entire institution is now captive to kind of financial and political forces that own the building.
Okay.
Womp womp.
Yeah, no, I mean, I wasn't expecting we were going to be skipping around here.
Yeah.
A minute ago, you talked about how it was that the incoming justices came to trust the public less. But I want to ask you about the other side of that. These days, the public does not seem to trust the court. What would it take for the public to come to trust the court? What are things that could change that would decrease our merciless approach to all of this?
Okay, the sad laughter in the back right of the house. I mean, this is where, and this is my bias, I think the court has squandered the public trust. I think that, and here's a place where I've just been wrong, I think that the court has always been in a kind of a dance with public opinion, with the American public. And you asked the structural question before and I didn't answer it. I mean, I think we all understand that the basic theory of, the three branches of government and checks and balances and of lifetime appointments and of insulating the justices from political wins. The theory is we need a counter-majoritarian branch, right? We need a court that is not going to, put up its finger and say, well, the public wants desegregation, let's do it. It's important, it's essential to protecting minorities. So I think we have to be very clear that when the court acts in counter-majoritarian ways, we can't just throw up our hands and say, well, the public doesn't like it, right? We want that, it's baked in. But then I think, just to go to your question, the court seems to now think that what the best way to sort of like show judicial independence is to just not care and to aggressively, I think, sort of fly in the face of public opinion, even on, and we can sort of tick down the things that I think that they could do to change it. But the simple things, like the low-hanging fruit, when the American public is telling you at like 86, 87%, they want an enforceable ethics code because every other judge in the country, every other Article III judge in the country is bound by an ethics code, and it's not like choose your own ending. I think I'm ethical, move on. It's not that. There's no ethics code in the world in which the justices are their own arbiters of whether they've crossed the line. And so to me, like that seems like the minute that was starting to become an issue, not saying, you're right, America, 230 years later, we probably should be bound by the same ethical rules at minimum that other federal judges. And instead to do this ridiculous song and dance that is like, well, we can't do that because it's a threat to judicial independence, and like we wouldn't, want to take away anyone's super yacht. And, I just think it is so mealy-mouthed and so sort of insensitive to the enormity of the problem. And I just want to point out, I think I wrote this week in response to the amazing piece by Jodi Kantor and Adam Liptak, the reporting on Sunday about, the sort of how the sausage was made in the 3 January 6 cases. I almost think the most interesting piece that didn't get as much attention as it should is if they are correct that Fisher case, which was, the statute that they were charging the insurrectionists with, and the court said you can't use that statute in that way. And that case was originally assigned to Justice Alito. And at least to hear, the Times speculation, this happens around the same time that the Flaggate 1, Flaggate 2 happen. And the most interesting thing is that this has never happened. Nobody has any memory of somebody losing an opinion, not because they couldn't get 5 votes for it, that happens, but because they did something, right, that the chief apparently pulls the opinion back and writes it himself. And the amazing part of that story is that Justice Roberts knew about the flag stuff years earlier. Mm-hmm. It wasn't the flag stuff that was the problem, it was getting caught that was the problem. And to me, if you needed a still life in the problem at the court, it's that nothing is a problem until you're caught. And then when you're caught, it isn't even like, maybe we shouldn't be flying upside down flags. It's, I'm going to quietly take away the Fisher opinion, presumably, if that's what happened, and maybe nobody will ever know what happened. And I just think that bespeaks a certain contempt for this public engagement with and public concern about the court that worries me almost more than the conduct itself, because if you can't be honest about why you're losing the people, you're going to lose the people.
How much should the court be thinking about the people? I'm asking that in part because we're thinking about the people and the public throughout this series, and in part because the court is deliberately structured to be less responsive to, say, you used the phrase public opinion a couple minutes ago. And I remember, I think it was Rosie Abella, the justice in Canada, who said, our job is to respond to the public interest, not public opinion. And public opinion is so loud now and comes from so many directions. And some of the things we were laughing about before, robes, all the things that make it seem to try to protect the court from being too subject to public opinion. So how can the court be responsive to the public interest but not be driven by public opinion?
Okay, I want that martini now. These are. I'm kidding. These are good questions. I think that the court is unlike the political branches insofar as you have to hold 2 completely irreconcilable ideas in your head all the time. And one is, there's a great book about this, that's like all judges are political except when they're not. And that's literally like the title, because you have to hold in your head that of course it's a political branch. It is by nature a political branch. You're, appointed by the president, you're confirmed by the Senate. It's a political office. and it's something else. It's that tension that I think animates everything you're asking me right now. What do you do with the branch that is political and also doing a different thing? Presumably, we used to think that this other thing was, triangulating against the Constitution or, close reading a statute, whatever it was. There was this second project. And the tension is, how do you live in that? And by the way, I've been incredibly and increasingly critical of the Supreme Court press corps because I think we err way too much on the side of the other thing, that second thing. They're oracles, they're great, we're going to interpret their opinions, we're not going to look at what's behind the curtain. And which is why, by the way, Jodi Kantor at the New York Times, who's an investigative reporter, is breaking these stories, right? It's why ProPublica is breaking these stories. The Supreme Court press corps is still like, in a spirited opinion today. I couldn't see it because I was in D7, but I'm told, this, we're still kind of taking dictation, a lot of us on this beat, and that's like mea culpa. But I think that the tension between the aspiration of doing something that is much bigger than just raw politics, like who you'd pull the lever for if you're voting, and raw politics, that's the work of the court. And I think that what the court has done is, instead of saying we are going to behave in a way that really bolsters and reinforces and reifies that second narrative, that what we do is law and it's different and it doesn't map onto our politics. That's their job. That's not my job. And I think that then, when instead of doing that, right, which is why I would say, have an ethics code. It's why I would say, if you have a conflict of interest, disclose it and don't, right? Those are all behaviors that would bespeak a commitment to that second project. If instead of that, you just say, we're closing all the windows, you can't come in, we're going to just keep lying to you, and you're bad for questioning us, right? That's behavior that goes in that category 1. And so I think that the real kind of tragedy here is that it was theirs to keep or to squander. And I think that and this is really important, this is if nothing else that I said today makes sense, I hope this does. Those of us who are critical of the way the court is conducting itself right now, it's not because we want to have no court. I think we need to be perfectly candid about the fact that whether we like it or not, this court, as currently constituted, will be deciding, I think, this 2024 election. It's not, we don't want this election to be fought out in the streets, right? That's how they do it in other countries. So we need to have a legitimate court because no constitutional democracy can continue without a legitimate court. And so those of us who are saying, oh my God, do the ethics reform, have term limits, have age limits. The numbers are astounding across ideology that people want, just basic things. We don't have to talk about court packing. Term limits, enforceable rules about disclosure and about recusal, and they do none of it. What they're leaving us with is the double, I think, tragedy of a court that is going to continue to be the court and an American public that is going to say, yeah, no, this time, no. I did it, in Bush v. Gore, I acceded to your decision, and this time, no. And that will not have been our fault.
So a lot of the changes that you just mentioned that you think the court could be making fairly easily are changes around process. And the chapter in Lady Justice on Me Too, for example, is largely about where is the clear, transparent, accountable process. And what's interesting about that, one of the things that's interesting about that is, I put myself in a group of people who responds madly to the content of the decisions more than the process. That's what drives me in some way to react. And so I think the question I want to ask is about how, especially a layperson, which is the great majority of us who don't know as much as you know, how should we be responding to the decisions that come down from the court? What should we be consulting as part of the public to evaluate whether these are legitimate? Should we be thinking about process, or should we be consulting our conscience and hoping for consistency with that? What is it that most of us that are not schooled in this should do to try to understand how to react?
So I love this question, because I think part of my own answer is you either believe that something has fundamentally changed on this court in the last few years, or you don't. I believe something has fundamentally changed. We haven't talked about doctrine that much tonight, but when you have a court that simply doesn't care about precedent, right? Or willy-nilly saying, yeah, Chevron was the law, now it's not. Roe was the law, now it's not. Whatever it is, the Lemon Test was the law, now it's not. I mean, when there are, and this a little bit goes to your, I think animating question about why justice, mattered to me and still matters to me. I think a huge part of it is predictability, right? Knowing you're going to get the same result time after time. It is what in the law we call reliance, an interest in knowing that you've organized your life around a world that works in a certain way and that it's going to be like that tomorrow, right? There are a bunch of markers for what is a process that gets us to a just decision. It's not feelings ball. I have many, many times covered cases that I would have decided differently, but I didn't say, no, this process is corrupt. But I think when you have a court that is, and there's so many iterations of the problem, whether it's deciding things on the so-called shadow docket, right? Cases that have not been argued, have not been briefed. There's a little back of the napkin 3 sentences that comes out at midnight, SB 8 in Texas. It's cool, right? This is Professor Steve Vladeck, and his book is amazing on this. But there's just marker after marker after marker. Last year, the EMTALA cases, the Emergency Medical Treatment and Labor Act cases, where the court reached out, took it, said there was an emergency, there was no emergency, heard arguments, and then said, oops, we shouldn't have taken this, it was way too early, right? So there are these process markers of the court not following its own rules, and whether it's the rule for when you reverse precedent, like there are very clear rules for when you can reverse precedent. We don't care. There's inventing a doctrine. There's a major questions doctrine. What is the major question? I don't know. It's what Justice Gorsuch says it is. And I think that we're just seeing the process breaking. And I think that there's a level of, the feelings ball piece of it, which is I don't like this outcome. And then there is, they're distorting the process to get to the outcome. And I know that sounds like a lawyerly answer, but it is the answer. And I think if you kind of pan back one from there, I would also say the process of even how we seat justices has now become so completely corroded, right? That, you can fight about whether it was a, Ginsburg rule or it was a Merrick Garland rule or whatever the rule was. But we used to seat justices when there were vacancies until we didn't, right? And then we created a rule that said we don't seat justices in an election year, but then we did, right? So I just think that process too has almost entirely broken down. And so when people have this kind of visceral sense, I'm trying to decide if I don't like Dobbs or if I don't like Bruen, the gun case, because I just don't think, we should make abortion illegal, or I don't think, everybody who wants a gun should have one because the framers hadn't invented the machine gun. I think those are kind of gut check questions that you're asking me. And I think separate and apart from that is the question of how did that case get there? Who argued it? Where did the money come from? And I think that this is where, last year I remember saying, we're still largely thinking about, and certainly reporting on the court, as though it's this laboratory, this pristine laboratory of justice, without saying, the laboratory has been, bought and owned and peopled with scientists by one side that literally is getting $1.6 billion donations to put people in the lab. And then we are being kind of acculturated to say, fascinating decision, in Loper Bright. And so I think we have to just be committed to the proposition that if we believe that processes matter, how far off this sort of procedural track do we have to be before we say this decision isn't a decision?
And even more than that, it sounds like this court isn't exactly a court. I mean, that's the direction that you used words like corrupted, corroded, broken down, one after the other. And at a certain point, I think I want to check in with my hopes and go, what am I hoping for from this? Would my hopes be better served by pointing them somewhere else? And so want to ask that question with reference to the kind of motion of the book and a couple of the women who you look at there, and Anita Hill, who has probably more reason to move away from the institution of the law and the court than maybe anybody, remains an institutionalist, remains committed to the law. Some of the other people you talk about seem to move from the law towards organizing. And that, in a way, the direction of the latter half of the book is to move out of the court towards organizing. So I want to ask you, as someone who did go sit in row C, with love, it sounds like, institutionalist or looking elsewhere?
So first of all, my favorite, I think we talked about this in the green room, which is not green. We were talking about, my favorite line in the book is like a colloquy with Anita Hill where I say some version of why you're still working, within the contours of this legal system that was designed and is perpetuating, violence against women of color. It is doing exactly what it was designed to do, and still you're trying to perfect it. And her answer, which I thought, was so eloquent, was there's no plan B. There's no other thing. When the rule of law breaks down, there's chaos, is what she says. And who never, ever thrives in a system of power and chaos is like women of color, right? Like, we will lose if it's fought out on the streets. And so we perfect it because plan B is like the militia, and that's bad. And I think that's really, she doesn't say the militia, she would never say that, I'm saying that. We have to perfect it because we don't have another thing. But you're exactly right, descriptively about halfway through drafting the book, I realized that, I like Law and Order too, and I love courtroom scenes, and I could describe, people winning in court every day, which was what the first half of the book was. And I was sort of having the realization that you and I are having on this stage, which is you can win all the court cases in the world and still lose democracy. And, we really saw that, right? We have seen that time and time again, that winning in court, which we have this notion that that's the arc of justice, that gets you halfway. And then the other half is fighting for democracy. And so the rest of the book, there's this moment, like I think Vanita Gupta, who at the time was at the leadership conference and now at the Justice Department, and she had also won a whole bunch of, she won this incredible policing misconduct case in Tulia, Texas. She was a lawyer's lawyer, and then suddenly she was at the Justice Department, and then suddenly she was at the leadership conference, and she becomes an organizer. And then Stacey Abrams and the sort of all the people toward the end of the book are much more involved in sort of organizing and in democracy repair. And Nina Perales, who's doing One Person, One Vote. And I think what I realized is that, just as justice is an aspiration, so is democracy. And we think that those things are, carved in amber, immutable things. They're not. And to the extent anything is carved in amber, it's sort of the injustice that is baked in to a constitutional system, right, that has an electoral college and a malapportioned Senate and, minority presidents who lose the majority of the votes, who are, then picking Supreme Court justices who are then confirmed by Senate that is, much less than half the country, right? We're baked in doing the same things over and over again, and the only way that changes is by organizing and changing democracy. And so then I just became very, very obsessed, and this is sort of the theme of the book, with these people who understand that we just can't win trials. We're going to have to do profound work on, reforming the Electoral Count Act, which we did after the 2020 election. And, state gerrymandering has to be repaired, and state Supreme Courts have to be repaired. Like, all of that work, which, by the way, like, I know that lights are off, but I know your faces are all like, because it's so, like, democracy reform, like, no one is ever going to make a Netflix special about, like, reforming the Electoral Count Act. But it's like, this is the stuff of democracy, and it's a dream, and we're not there. And these women who are just, like, never going to get famous, they're never going to get, millions of dollars, they're never going to have a Netflix special made for them. But they are doing this amazing in-the-trenches work that I think is, if we can do it correctly, going to perfect democracy. Not just justice, but democracy. And, like, I mean, dude, I have goosebumps. Like, when I think about that as the job, as opposed to winning trials, which is just, like, feels really good, but it's not going to get us there.
I love that you just said, dude. I think I have a sort of impolite question, and it's related to something that Roberta Kaplan says in the book about why she's drawn to law initially. And it's because she's suddenly surrounded by all these very smart people. And she realizes, like, these are the smartest people she knows. And so I think the impolite question is, why is it so hard for all these smart people who agree to do what's right?
In the context, do what's right in the context of
democracy or inclusion. Take any of the big words we're after and whose absence we're lamenting. Why is that so damn hard?
I mean, I think there's a couple things happening. And this is the Slate, like, my producer of my podcast says, you're not even like Eeyore, you're broken Tigger. Like, she's like, Eeyore I could handle, but you're just like, you used to be so bouncy and now you're so sad all the time. And I think one of the things that worries me, and it goes back to our sort of celebrity culture question, is that I really came up, in a time where we were all like, I don't have to do anything because RBG is going to fix everything for everyone. Like, if I just buy, like, the votive candle, the mug, the earrings, the dissent collar, watch both movies twice, and, have the throw pillow, like, we're good. Democracy is safe. And I think, and I quote my friend Rebecca Solnit in the book, talking about how we have very much metabolized kind of a culture of, Kamala's going to fix it, or, Trump is going to fix it. Someone's going to fix it, and I'm going to, like, that popcorn emoji, like, to me, that's the symbol, right? That's the physical manifestation of, like, the popcorn emoji means, like, you're enjoying watching politics as opposed to being in it. And I worry because Rebecca Solnit describes it as like a culture of, the great man in the white hat who comes in and saves us all. And that's, the stuff of history books, and it's certainly how we think about organizing in democracy. And my fear is that we have become a little bit passive, and which is also a little bit my fear of, when everybody got all hopium, when Vice President Harris got the nomination. Again, it just felt, vibes and I don't have to do anything anymore. And so I am, like, very, very much a proponent of, as long as we keep kind of conscripting famous people to do the work, and then we just go to Target, we're not going to fix anything. Like, we'll have a lot of nice scented candles, but I just think, we're not fixing it. And so part of my answer is, I think that a lot of us, for a lot of legitimate reasons, just lean way out of this. And, we're really seeing it. I mean, we haven't really talked about abortion at all, but, like, what I'm seeing When I go to Ohio or Wisconsin or Michigan and talk to people who are trying to get reproductive freedom on the ballots, is this like incredible anxiety. Women who are like, I really hated Dobbs, and I know like I should have skin in the game, but I'm not political. And so I think a big, big part of it is that like we would rather talk about, anything, but, sort of how urgently important, not like in the I hate you, you hate me, like the sort of surface way we're doing politics, but in a deep, meaningful way about what political engagement is and what civics is and what we believe and what we value. Like none of that, right? Because we're just lobbing insults about, eating cats. And so I think like what I want to pull sort of, and what I really did pull from the book and from your question, is that I think that we have to own this and like embody it in our day-to-day lives, not just a couple times a year, not just get out the vote, not just buying merch, but really, really say like the whole, dream of whether this thing rises or falls isn't like having other smart people do it. It's we have to be the smart people who do it. And like the beauty of those like living rooms of women in Ohio is they're doing it. Like they've got, abortions on the ballot in 10 states. And in the 7 states it's been on the ballot, it's won. Like this is manifestly doable. But I think it's just like almost like under your question is an assumption that like all these smart people are working on it. And it's not, right? We've got a bunch of like sort of like skin stretched over ambition people who like run for office because they want, to be famous. And then we just say, lead me. And I just think like if nothing else, the proof that like that's not adequate anymore is this moment that we're in.
Right at the end of that comment, and this is the last question I want to ask before we open to audience questions, went back to your first response about wanting to get a lawyer for the kids at the camp that you worked at. And in a way, that impulse to want to get a lawyer feels like looking elsewhere. It's just interesting to think of when do we look out, and what does it mean to look for the educated, the lawyer who represents some version of some vestigial aristocratic thing. When is it the kind of thing that shouldn't depend on the law? The question I think I want to go toward there is related to the word battle in the subtitle of your book. So the book is called Lady Justice, Women, the Law, and the Battle to Save America. And I think you were just talking about fighting. And in a way, as I was thinking about that subtitle, I was thinking about the verses in every case, that it's got this intense little VS right between, like it's all a fight. I think the question I want to ask you is, how do you think we should fight? What does it look like to fight?
Yeah, there's too much fighting. I think, that V between the two names in the case doesn't presume fighting. It presumes, right, an adversarial system in which you check facts against alternate, right? I think that that doesn't have to be a fight. And I think one of the things that has been very scary, and I don't want to go down the rabbit hole of AI and like Iran and bots and what's going to happen in this election, but I think that V in between the two parties in a case is symbolic of an agreement that at least the facts are shared. And if we go back to your process question, the process is shared, right? This is how we do it. And as an organizing matter, I think that's a really good piece of fundamentals, right? If we can agree on shared facts, if we can agree on a mutually agreed upon fair process, right? What I am terrified of, I know this wasn't exactly the question, but I think we're now living in a world where facts are just immaterial. And facts are completely conflated with your feelings, and facts are conflated with like the thing you just saw on TikTok. And this is, a personal sort of bugaboo of mine, but, the Supreme Court, which is inventing facts and putting things, into the doctrine that are not true. Like, this is really starting to happen. And I think that the sort of dissolution of facticity is the real thing. Like, if I were to say across ideological lines, political lines, party lines, the only thing that I could implore people to battle for is a world of shared facts, knowable, discernible truth, because I really, really do think that we are on the precipice, if not like, the coyote like running in the wind over the precipice. We are right there in a world of no agreed upon facts. And you cannot do law, you cannot do politics, you certainly cannot do academia in a world in which there's like the Venn diagram of my facts and your facts like don't even, right? They're like googly eyes. And I would say in whatever space one operates, to be, like I say this to young journalists all the time, it is not a line. When they fact check you and put a correction on your piece, and you die inside and you're like, oh God, I hope my mother doesn't see like I made a mistake, like that's a great day. Every time some system exists to correct you, that is a great day. And so I just think the battle almost has to be for, we can't talk about challenging, truth versus truth if we don't have shared facts. And so in whatever lane we operate, I think trying to sort of restore systems that allow us to say, not you read that paper, I read this paper, you watch that station, I watch this station, this is what I think is happening in the world, and this is, but like some agreed upon methodology for knowing what is true and what is false. And I really think if I know that's like a very inchoate answer, but I think if we don't do battle for restoring like the law, the journalism of the academic focus on shared facts, then everything else falls away.
Yeah. There's so much more that we're going to try to keep asking Dahlia about, and so I want to encourage, as people are ready, there's a microphone over here which is lighting up now, almost by magic. Thank you to the folks at Alberta Rose for that. I have a request, which is, I heard it said that lawyers are told never to ask a question that they don't know the answer to, and I would invite you to ask questions that you don't know the answer to. That's the kind of question we'd love to hear, and it might take a minute for people to filter up. I know there are questions in here, and while people are emboldening themselves to ask questions, can we just say a big thanks to Dahlia right now?
Thank you so much. I really appreciate what you said about needing the organizing and the activism as well as the law. I think that's so true. I work in the environmental protection area in the law, and we have always known that our legal wins are really a part of a larger strategy, and it's really one tool in our toolbox. Speaking to the Supreme Court now and the environmental movement for a moment, I know that the youth climate case, the Juliana v. US, just filed a petition for review. It's on a procedural issue, so kind of turning back into this procedural question about whether the Ninth should have issued a writ. Sorry for all of you non-lawyers in the room, but should we be doing that? Should the environmentalists be just like, take a pause until we reform the court? What's your take on that? Thank
Yeah.
you so much.
I mean, that is the question, and we're seeing it in the gun space, right? We're seeing, you know, the Biden administration is not appealing a whole bunch of these gun decisions, and you know, certainly the reproductive right. I mean, we're now in a posture where it's like, what happens if it's worse, right? After the court gets its hands on it. I don't have a great sort of tactical answer. I mean, I think my view is, you know, sitting around waiting for things to get better and not aggressively litigate doesn't seem, I mean, you know, you are in some sense doing this to construct a record and to, you know, make a point and to, again, marshal facts and arguments. I worry about the temptation to, like, nobody ever appeals again, because it is sort of, you know, bringing that sense of we can't possibly win to the sort of macro level. At the same time, I fully understand the fear of, you know, we have a good decision here, it can be contained here, or we have a bad decision here, it can be contained here, rather than have it be nationwide. I guess my view in the aggregate of this is that one doesn't just do this to win at the Supreme Court, right? I mean, one does this in order to tell a story, and that particular case is just a spectacular story that has, I think, inspired the nation. And so my view is, you know, and I think this is just probably sounds like a platitude, but I really mean it. I think you swing for the fences in the understanding that, you know, there will be setbacks, and then, you know, in years to come, the pendulum will swing. But I think, you know, I remember once asking, I guess it was Justice Ginsburg, why we write dissents at all. And for, you know, there was a huge debate when the court first became the court about whether there would even be dissents, because I think it signals, you know, discord, and you want to be brains in a vat. And Justice Ginsburg's answer, I thought, was very beautiful, and it was, by the way, Justice Scalia's answer too, which is, we're writing for the next generation. Everything we are doing in the law, we are doing for, you know, the people coming up in law school. And so I think that's my answer, is that you are not doing this to win this year. But you are doing it because there is a generation of young people who care ferociously about the environment, and they need to have modeled for them, this is how we fight.
Thanks.
Thank you for writing your book. And I have a question. I'm not sure if it's for your broken Tigger or your Eeyore, but I thought I heard you say that the 2024 national election will be settled by the court. If that's the case, then what are the chances that Trump is not the next president?
Yeah, I was afraid that question was coming. I was sort of hoping we just slide right by it. I mean, I think we have to be very realistic, and we're already seeing this happening in the States, right? We're already seeing, you know, in North Carolina, in Ohio, in Georgia, we're already seeing, and I urge you, I really implore you, I know, like, state Supreme Courts are not, like, the hottest topic in jurisprudence, but we're really already seeing, I think, efforts to Ari Berman was on my show 2 weeks ago, and he's kind of my voting rights, one of my voting rights kind of gurus. And he said, you know, we are already seeing around the country that lessons from 2020 were learned. And so things that were done in the 2020 election that were done badly and sloppily, and, you know, calling Brad Raffensperger and asking for precisely the number of votes, you know, like, the level to which that is not going to happen in January, that's happening now. And, you know, we're seeing it in Georgia already, you know, putting people who already sort of denied the last election, putting them back into office, and we're seeing, right, that they are being empowered with the ability to interfere with vote counts. I mean, this is happening. And so I think we just have to be very, very candid about the fact that whatever the outcome of the election is, things that were done slapdash, sloppy, with bad lawyers that were very easy for the courts to bat away, and often on procedural grounds, are going to be like robustly argued cases by very good lawyers. And so that's happening. It's going to continue to happen. And I think that when I think about one of the tricky things is like, is it going to be, like when we had Wisconsin in COVID, right, and their measures, and which was also decided, on an emergency posture by the court. Like, we don't know what the thing is. We can sort of guess which buckets of challenges are going to come and from which states, but we don't know. And then I think under your question is the harder question of, how much do we read the immunity decision, the Anderson, Colorado decision, the Fisher decision last year, which seemed to be 3 decisions putting a thumb on the scale for Donald Trump. And certainly, we now know from the New York Times reporting, making it impossible, utterly obviating the possibility of a criminal trial, right? So there's a way in which you can say, like, that election interference has already begun at the direction of the Supreme Court. So you're right to say there's a lot to be worried about. I will say, and I taped this week's show this morning, this week's podcast with Linda Greenhouse, who covered the court for 36 years and won a Pulitzer Prize. And she gave me this piece of solace, which you get, Linda Greenhouse, A1, maybe A2. She gave me one piece of solace which helped immensely in thinking about it. She said, and I hadn't thought about it this way, the Fisher case, the insurrection, the statute charging the insurrectionists was always, going to be a tough lift for the Justice Department. The Anderson case, we never thought they were going to take Trump off the ballot, and nobody thought that Trump was going to lose that case. So then the question is the immunity case, right? That's the thermonuclear one. And she made the point that I hadn't thought about before, which is if you track John Roberts' career, he is a maximalist executive power guy from the jump. That he was that in law school, he was that at the Justice Department. This was an executive power decision. And the line in Adam and Jody's piece about how he really thought if he could write an abstract immunity opinion about, separation of powers and executive power, and the American people would be like, cool, okay. He really believed that, and not because he's mad, for Trump, but because he was making what he thought was a pristine executive power decision. And I think her view is that's not necessarily predictive of, him sort of wanting a thumb on the scale for 4 more years of Trump. And I confess that I read all those 3 cases as of a piece. So I think, my answer to your question is yes. I am deeply, deeply worried, and I don't know anybody who isn't deeply worried that it's this court that will be deciding this election as litigated. Again, this is not going to be, Rudy Giuliani and, Sidney Powell this time. These are real lawyers, and they're going to be real. All due respect to Sidney Powell, but these are going to be real cases, and I am very afraid. And one of the things, and it really, really goes to this question about democracy, is we cannot be thinking only in terms of winning lawsuits. We have to be thinking about massive, massive structural democracy reform, because, these cases are sort of like the beginning of the story, and they're not the end of the story.
Thanks.
Mm-hmm.
Well, conveniently kind of taking off from that. We've all been focused on the concept of threat to democracy and the series of cases culminating in the immunity ruling that shattered our illusions that what we thought was a shared value of democracy Apparently, it's not sure. But if you look at those rulings, you can figure out a basis for them just based on power. Someone has to have power. They're making a ruling for someone in power. But then I go beyond that to some of the other rulings that indicate to me a desire or a drive to get to chaos and out-and-out authoritarianism, exemplified by the latest ruling came out this spring in the series of rulings that effectively eliminate the crime of bribery and corruption. And I'm just baffled. I can't understand that. And like I say, all that shows is if there is not agreement that bribery is a crime, then chaos. Do you have any thoughts on how we got there and what it means for the court?
Yeah, that's a great question. I mean, I think my critique of the court and its approach to, and we haven't really talked about this much tonight, we talked a little bit about reversal of precedent, and we talked about taking cases, off the shadow docket that are not ripe. I mean, those are procedural questions. You're asking a substantive question, which is what do we do with two things that I think are equally dangerous. One is the court arrogating to itself the power to decide everything, right? The court has now said, we are experts on all things, including, air pollution, right? In the Clean Air Act, we can tell you about swampland the year before in the Clean Water Act. We're experts on every single thing. This is where, Justice Gorsuch in the Good Neighbor case, the Clean Air Act case, accidentally says nitrous oxide, right? Where, like laughing gas when he means, because it turns out he doesn't actually have a PhD in particulate matter. But it's both sides, by the way. I mean, I think they have just made themselves the deciders, and partly that's a function of having a supine Congress, right, and executive branch that is hamstrung. So the court's just like, now we decide everything, and that's one substantive critique. The other, what you're saying is really subtle and I think really important, which is what frightened me most in the immunity arguments was the disdain about Justice Department lawyers. It frightened me in Fisher, the disdain. What frightened me in Bruin, the gun case, was the disdain for the people who are handing out gun licenses in New York. What terrifies me in the abortion cases is the disdain for the physicians, right? They are, in their language, seeding this idea that there's a deep state, right? That's like a Fox News idea. That's not a jurisprudential notion. They're seeding the idea that, government functionaries, sit at their desks and take stuff away from you, right? This is a widespread effort to sort of foment mistrust in structures and institutions. And what slides in, and I think this is part of your question, I think is vigilantism and self-help. Once you start saying, as Justice, again, I feel like I'm picking on Justice Alito, but oh well. As he said in the Bruin case at oral arguments, that people need to be able to have guns on subways to defend themselves. And once you're starting to do that sort of Kyle Rittenhouseification of how we are going to be safe, I think you're down the rabbit hole. And, don't forget SB 8, the Texas, bill that the court blessed on the shadow docket is also a vigilante bill, right? It's like turn in your neighbors, turn in your healthcare workers. And I think like what you are pointing to is not just, the blessing of corruption, the saying, go ahead, unless you have like a huge like Scrooge McDuck money bag that you throw on the table and say like, and there's dollar signs on it. It's not corruption, right? But that is of a piece with, I just think, a much, much larger kind of contempt for the administrative state, right? For agencies, for expert decision making. I mean, the entire, sort of post-FDR construction of how we govern ourselves. And what has replaced it is this kind of ethos of suspicion and mistrust and self-help. And what really, really scares me, if you want to go there, is the marriage of that mistrust lashed to voting, right? Because what we are saying is, go ahead, take your gun to the polling place. Go ahead, because we now believe that, nobody can be trusted to ensure that, your vote is legitimate other than you telling your neighbors. And what I really, really, again, and this goes to like my sort of point about facticity, I think when you are pushing out ideas that it is every citizen's job to replace like all of government and to do so with a gun in her hand, I think you are fostering exactly the most dangerous to democracy culture that you could possibly foster. And I want to believe, I'll conclude here, I want to believe that when the justices say things like, the school district lawyers, cavalierly dismiss, I want to believe they don't realize they're doing that, planting the idea that every lawyer who works for government is, a corrupt shill, but it is ever present now in the language. And I just think that when you put that together, we've got such scary, last year was bump stocks, which was scary enough. We've got the ghost gun case is going to be argued the first week of the term. And I just think, could there be anything more volatile than sowing doubt in government and giving people unfettered right to guns? And that is the sad tromboniest thing you are going to hear from me tonight. But that scares me a lot.
Hi, thanks for coming to Portland. I have to say that I was deeply flabbergasted when Mitch McConnell was able to prevent Obama from even putting Merrick Garland forward. And what I was flabbergasted at was the lack of public outcry, that there was silence. And I thought, where are the people demonstrating? Why aren't people banging on the doors? And I haven't felt that way until the immunity decision. And so I wrote some letters to people about organizing a march, We the People Dissent, and I got no response. And here we are, we're coming up on the first Monday in October, and I'm thinking, dare I go out by myself with my little sign and stand in front of the Supreme Court? And I'm not sure what my question is, other than, is that a really stupid thing to do, or has there ever been any organized protest against the Supreme Court? Because I'm not aware of any. And it just feels like it's time.
So I want to just reassure you on one front. I completely agree that the entire political left was on screen save. Mm-hmm. That year when literally Mitch McConnell was like, no, we're just not going to, not even not going to have, we're not going to seat him. We're not going to have a hearing. We're not going to have courtesy meetings with Merrick Garland. And I just want to be super clear to your point. That was a year in which we had one vacancy on the court and 3 80-year-olds. All due respect to the 80-year-olds, that might have been a time to think about the composition of the court. And we know from the polling 2 things. We know that Democrats running in that 2016 election did not message it, did not talk about it. It was a non-issue. And at the same time, we had Ted Cruz, we had Mitch McConnell, we had every single person, John McCain, running for office saying, I will hold that seat empty for 8 years. We are not seating someone in Scalia's seat. That is Scalia's seat. So there's a huge asymmetry. And surprise, surprise, the polling shows that after the 2016 election, by a 2-to-1 margin, people who cared about the court voted for Donald Trump. So you are right. This was an abject failure. And I remember, you will not remember, but I actually got Ben and Jerry's to do a contest with me to name an ice cream after Merrick Garland. I think we came up with impeachment, like a reader contest, just to get people to care a little bit about what was happening that summer, because people didn't care, stipulated. If you look at the polls now, if you look at the sea change in public sentiment around the court, there was a Pew poll this week that said that the court was the number 2 or number 3 issue for progressive. That's all attributable to Dobbs. It has changed. The groups, in 2016, there were 2 groups doing the work of judicial reform, judicial ethics. There's about 8 of them now. They are big, serious groups doing huge work, and the public is with them. And the polling shows the public is with them. Now, that doesn't get us all the way there, but it means we're not asleep. And that's the start. And I also just want to say, I got a letter yesterday from a woman who is 80-something years old, who is flying to the court on the first Monday of October to wear a suit that she wore when she argued a case at the court, I don't know how many years ago. And she's going to stand there with a sign, and she'll be very, very happy to see you there.
All right.
But this is, I think, this learned helplessness of, we're just stuck with this. It's ever been thus. It will always be thus. I think that was terrible, and I really believe that's over. And the best way to show yourself in the world that it's over is to just, you don't have to go to the court, you don't have to do a march, but you have to every single day commit to court reform being one of the things you work on.
Thank you.
Thank you.
Thank you. You've spoken tonight based on some of the questions and your comments about voting rights. And one of the things that has been very concerning to me is the way the court has backed off the protection of voting rights, turning a blind eye to gerrymandering, turning a blind eye to voter suppression. And I wonder what your thinking is on that as to why the court has just abandoned protecting voting rights, which is so essential to democracy.
Oh, that is a beautiful question, and I think it's slightly answered by, Justice Alito famously says in Dobbs, if you don't like it, go fix it at the ballot box. And this is the same, Justice Alito that had just written the opinion, right, eviscerating one section of the Voting Rights Act. And I think we just need to be very, very clear that if you want to, in a sort of pluralistic, changing democracy, if you want to keep protecting minority rights, you have to do it at the ballot box because that's the only way to do it. And, vote suppression, look, we've had more vote suppression in this country than we've had voting, right? There's always been vote suppression. And by the way, the playbook we're seeing now is straight out of Jim Crow. These are all the same plays. So I think the simple answer is, and we know this, John Roberts, when he clerked for Rehnquist, when he worked at the Justice Department, his raison d'etre was constricting the vote. And you're also right, and this is really important, that each voting case that you read Shelby County, and they're like, oh, we're doing away with Section 5 of the Voting Rights Act, but don't worry, you'll have Section 2, and now, right, they're coming after what's left of Section 2. So I think we have to be very clear-eyed, both that this is the way you effectuate minority rule, which is by suppressing majorities. And we are seeing that, I just last week was reporting on, in Florida, where there's massive majorities that want to get Amendment 4, which is the ballot initiative to get reproductive rights on the ballot. And people are literally knocking on the doors of people who signed petitions. And the cops are coming to their homes, right, and saying, are you sure you signed that petition? So I think this is, in some sense, right, this is the proof text. If you want to keep, pluralistic, tolerant, democracy from taking power, the only way to do that is to shrink the vote. And the way you shrink the vote is by having a court do it. And so I guess I would just say that's the why. And the answer, I think the sort of curative for that has to be that we are constantly working on all the ways in which, and I talked about a malapportioned Senate, we talked about, the Electoral College, all of the ways that we tend to think like, oh, ours is a perfected democracy, in which everybody votes. It's never been that, and it's still not that, and it's not enough to say, oh, we're for or against voter ID. It's what do we do to construct a democracy that was built in order to protect, minority rights? What is that work? We talked about organizing. What would that look like to have an actual democracy? And just to be very, very clear, other countries have protections against, this kind of minority rule that chokes off the vote. So we have to think about whether that means, the court can't just willy-nilly reverse the Voting Rights Act that was, reauthorized multiple times by huge majority. There are ways to do this so that the court doesn't have jurisdiction over that. So I sort of add that to your list of ways that we would have to say, not just that everybody gets the vote, but that every part of this system that prizes some votes more than other, that too needs to be fixed.
If I could just follow up on that, and I agree exactly with what you're saying.
I'm going to ask, if it's a follow-up, I'm going to ask to be very short because I want to make sure we get to one more question after this.
It'll be very short. And the question I have is, why? I can understand people trying to manipulate votes at a local level to gain advantage or at a national level to gain advantage. But why would the Supreme Court go along with it?
I think that, is that some of those people were seated to do exactly that. Why? Because if you have spent your entire career committed to the proposition that we're not counting every vote, you probably look very, very attractive to a legal movement that wants to do just that. I think that it goes to the question of how we seat and choose people for the court, and it is certainly based on track records, and we have ample evidence that several of the justices on the court right now have always been opposed to the kind of fulsome voting that you're describing.
Thanks.
Mm-hmm.
It's almost over. Thank you, Dahlia and Adam, for a great conversation tonight. And my name is Jo, and I practice intersectionality in my life. And I feel the court is a really great example for intersectionality to play out. And tonight's conversation, I hear a lot of repairing, fixing, fighting, battling, etc. I guess a very big question, which I don't know if I have answer for tonight, is what if the court, as part of the system, is a signal that the great American experiment has failed?
You brought in the big guns right at the end, yeah.
And no, it has a better ending. As we all can see here, as we talked about, everything we're doing today, this moment in this life, is for the next generation and the next generations to come. However, we see today, the younger generation is not here. And as you mentioned, when we talk about repairing the court, repairing the system, people feel boring. What if the younger generation has lost hope in this system? So my ultimate question is...
This is, by the way, how Justice Breyer used to ask questions. It was always like a three-parter, and you could see the poor advocate would be like...
So the question is actually better than things I said leading up to it, is how do you, in your perspective, reinstall hope to the public for the next generations who's not here? And after all the work you've done and writing this book, do you still feel hopeful for our collective future?
You stuck the landing. That's perfect. I think I could answer that question for 17 minutes, but I'm going to try to do it quickly. One of the through lines in the book is how many of these lawyers say, when I asked every one of them what gives you hope in this like deeply broken system, and every one of them said the young people. And then there was always a turn that I think is really important, and it's your point B, which is our young people by and large do not believe in institutions. They do not come to meetings. I love that the pollsters are like, we called all the young people on their home phones. Good luck. I think they're not joiners. They don't go to meetings. They don't organize the way we did. And I think that's a kind of a double-edged sword. I think it makes them very hard to organize, very hard to corral in the ways that we think are appropriate. And I also think it makes them hair trigger ready to, on a dime, do environmental work. On a dime. I mean, my God, the kids on the guns, kids on the environment, and sometimes they seem like they're just running around in circles, and you're like, here's an institution that might help you. And they're like, no, we'll do it this way. But I really, really, I'm both scared because I think under your question, we talked about democracy is an aspiration. It's not a cathedral. Justice is an aspiration. It is not a cathedral. Everything that we are doing is made of vapors. And so when young people say to me, everything you're doing is made of vapors, they're right. But I do think that even though they don't necessarily want to do this repair work the way you and I might, they may not, go to law school and clerk for the judges, and they may not, join groups, and they may not organize the way you and I do. They have such a deep, deep sense, just to end where we started, of justice and injustice. Way more evolved, I think, than mine was. And I really think, where I get hope, I'm scared, by the way, on the fake facts thing, oh my God, we have to fix it for them. But I do think that their impulse, that a lot of the stuff that we think is magic is not true, but that they can build something that really is magic with their hands. I just think they're amazing, and I see it so often. And maybe being too wedded to these institutions is our flaw, and that the gift I think that I see them giving me is saying, some of your institutions, as you said, are failing, and so I'm going to just do this directly. And if it ends at the place, where Adam, asked the question of where are the smart people, and why can't they agree? I think they might be the smart people.
Thank you. Thanks for the question, Joe. Thanks for the last question. I think Joe gave us a lot there. And I do want to, Joe, what you said about this room and other rooms, I think it's worth thinking about how many rooms people are talking through these things, and sometimes not in rooms but outside. And I want to use that as a pointer towards other Oregon humanities programs. We try to get people talking across differences in the ways Dahlia mentioned before, with other programs and other places, some not Wednesday night late when there's homework in school and other things to get to. And I'd encourage you to check out the Conversation Project. And the next one of these is going to be November 10th, which is a few days after the election. And we're bringing in a young person named Manu Meal, who runs an organization called Bridge USA that works at colleges and high schools to try to help young people build chapters that get folks talking across differences of political background especially. So that's what we're going to try to get people talking about here right after the election, when there are going to be many things to be thinking about. I want to thank all of you for coming out tonight. I want to thank people that also joined online from, as far as I know, all over the country. So thank you for doing that. And thanks to many of you for supporting this kind of work tonight and more generally. There is so much more that is in Lady Justice that we didn't even get to start. So I just encourage you all to check out the book, to listen to Amicus, the podcast, and to keep paying attention to what Dahlia is up to. And I hope you'll join me in saying a really big thank you to Dahlia Lithwick. Thank you.
Thank you, Portland.